As you know, I'm Shanna Welsh-Levin with SoCal Realty Law. I am the owner and managing attorney of SoCal Realty Law. At SoCal Realty Law, we protect residential investors and real estate professionals. I have been an attorney in San Diego for almost 19 years and also a licensed broker for about 16 years. I've only ever practiced in San Diego County, although at SoCal Realty Law, we do take cases that go all the way up to Los Angeles County, Riverside, San Bernardino, and out to Imperial County. But most of our cases are here in San Diego County. About a third of the practice is landlord services. We do not represent tenants. And we also provide a variety of other kinds of litigation services, mostly fraud litigation on plaintiff's side, meaning we represent the individual who has been harmed and they are suing people to try to get compensation. So we do landlord evictions, we do other kinds of litigation for mostly residential situations, and we do some residential transactions. But I don't use my broker's license to do sales. I don't take listings, I don't show buyers around, I don't take business from brokers. The transactions that we do are generally a seller who's found their own buyer, a parent to child or interfamily transfer, and other kinds of unique situations where people just need the transaction done for them. I'm also the president of a nonprofit. Even though we do evictions and the legal process is not always pleasant, I always have believed that housing is a human right. Everyone needs shelter, everyone deserves to have shelter. And right now we have a lot of problems with addressing that right or that need. And so I have a nonprofit called Amicus, and we provide emergency sleeping cabins to women and women with children who are at risk of homelessness. I'd love to tell you more about that project at some point in the future. Let's get started with our topic today. This is your legal update regarding the City of San Diego tenant protection regulations. And now the tenant protection regulations are active, and the City of San Diego has successfully enhanced residential tenant protections. The enhancements primarily focus on no-fault evictions and relocation assistance, but you'll find that there are a lot of details that have been added or changed to the law. What the City of San Diego used to have is the tenant's right to know regulation. And this new residential tenant protections, that the name of the new regulation is residential tenant protections, it does replace Division 7 of the San Diego Municipal Code. So Division 7 used to be the tenant's right to know regulations, and those are now being replaced with the new residential tenant protections. So the new law in particular has a bunch of exemptions. You'll recognize many of the exemptions, but some of them are slightly different from our California rent cap and just cause law, which has many of the same exemptions. In particular, the new law, the San Diego law, states that protected tenants include those who continuously use or occupy the residential property for more than 30 days. And I want to add the word non-exempt to that because it only applies to tenants who occupy non-exempt properties. The first exemption to the statute is when a lease is for a fixed term of 3 months or less. And that includes if you have a 3-month fixed term lease, meaning, tenant occupies from June 1 through September 1. And then if you extend that from September 1 to December 1, a 3-month or less fixed term lease is exempt. So if you're not sure about the new tenant, you're just trying them out to see if they're going to be a good tenant, you could do 3-month leases for up to 1 year. At 1 year, then the California rent cap and just cause law kicks into place, and you can't avoid that one by doing another 3-month lease. But you could do 4 extensions of a 3-month lease to avoid this for up to a year. Okay, then there's a list of exemptions that are automatic. You don't have to do anything or document anything in order for these exemptions to take place. You just have to fall into one of these categories. Those are hotels and motels, transient occupancy, And then we have short-term residential occupancy, which is also transient occupancy. Those are for hotels and motels. The revenue and taxation code says 28 days or less. For short-term residential occupancy, the local regulations are 30 days or less. Then exempt is also the deed restricted affordable housing. That's a special kind of affordable housing where it's stated in the deed and you would know it if that applies to your property. Then subsidized rental housing. But interestingly, under subsidized rental housing, they took out Section 8. So the exemption to the statute does not include properties where you have a Section 8 tenant. So the Section 8 tenants will be, so this regulation will apply to your Section 8 tenants or to landlords who have Section 8 tenants, unless they can claim the exemption that we'll talk about on the next slide. Mobile homes, mobile home parks are exempt. Nonprofit types of housing, such as hospitals, religious facilities, extended care facilities for the elderly, elder care, and transitional housing are exempt. Transitional housing is a special definition where it's 2 years or less and the occupants have a case manager and the nonprofit is running those. Then dormitories for institutions of higher education are exempt. Then we have a few exemptions for owner-occupied properties. So roommates. Roommates, when an owner has roommates, they're leasing to roommates. This type of tenancy is exempt both from these new regulations and the California regulations. That's where the roommate shares bathroom and kitchen with the owner. And then we have owner-occupied properties that have up to 2 accessory dwelling units, junior accessory dwelling units, or mobile home units on the property, or an owner-occupied duplex. Now, this owner-occupied exemption only lasts as long as the owner continues to occupy the property. If the owner moves out, then the property becomes subject to the new law. And then we have properties that are less than 15 years old. Okay, so then for the next exemption, it relates to single-family residences. And if you're familiar with the California rent cap and just cause law, you have to claim the exemption in order for a single-family residence to become exempt. That is very similar with the San Diego law, except it's different language that needs to be included in the exemption. So the new notice of exemption language is required if, and the owner may claim the exemption if the property is not owned by a real estate investment trust, a REIT, R-E-I-T, a corporation, or an LLC if one of the members of the LLC is a corporation. So the difference is some people use an LLC for estate planning purposes and the members of the LLC are individuals. That type of LLC may claim the exemption, but an LLC where the members of the LLC include one corporation or more, just a single corporation, means you can't claim the exemption. And then mobile home parks and managers of a mobile home park cannot claim the exemption. Actually, let me say it differently. The exemption cannot be claimed by someone who has a single family residence and is that is owned by the management of a mobile home park. Check in with me later if you need more details on that, because that's a tough one to explain. Okay, so then if the owner may claim the exemption, they may do so up to January 1st, 2024 by simply giving notice to the tenant. It's not required to be included in the exempt property's lease until January 1st, 2024. And after January 1st, 2024, it does have to be included in the lease in order for the property to claim the exemption. Prior to January 1st, 2024, you could do a notice of claim of exemption, or you may include it in your lease. Okay, so that part, I think, is very similar to what we've already gone through with rent cap and just cause. And then we have some protections that some of the at fault and no fault just cause definitions that are different. Some of the way that we will apply the law to the tenancy is different for non-exempt properties. First of all, a big difference between the new San Diego law and the California rent cap and just cause law is the new San Diego law is effective immediately at the beginning of a tenancy. The only exception to that, other than the exceptions we just talked about, so for non-exempt properties, the only exception is that if it's a fixed term of 3 months or less. In the California rent cap just cause law, it does not take effect until the tenant has resided in the property for 12 months or more. And then if you have additional tenants coming into the tenancy after the initial tenant, it may be delayed up to 24 months. If you look at the old San Diego just cause law, the Tenants' Right to Know Act, it only became effective once a tenant had lived at the property for 2 years. So this is a big change. It's effective immediately. If you're not exempt, that's a very important thing to be aware of. And by effective immediately, I mean at the beginning of the tenancy, but also know that this new law is now effective as of Saturday, June 25th. This new law is now effective in the city of San Diego. So then we have the at-fault just causes. Most of these are the same at-fault just causes that you've seen before. At-fault versus no-fault just causes. Let me just define this for you. An at-fault just cause is where the tenant does something and they are at fault for the landlord's need to evict them. So the tenant is causing their own eviction based on something that the tenant has done. No fault just cause is where the landlord has a reason to terminate the tenancy and may have to evict the tenant based on a reason that is not the tenant's fault. Okay, so at fault just causes are defined mostly the same. We'll go over a few little differences, but the big change is that for breaches of the lease that may be cured by the tenant, something like non-payment of rent or having a pet when the lease says you're not allowed to, things that the tenant can cure and then stay, you have to do 3 notices now. The first notice is a right to cure. It's a 3-day, or if the lease provides additional time, you have to read the lease carefully, 3 days to cure. And then if the tenant doesn't cure, the landlord has to then provide a notice to terminate the tenancy. So the first notice is the right to cure, but it doesn't terminate the tenancy. The second notice is to terminate the tenancy and does not give the tenant any additional time to cure. If they fail to cure in the first 3 days, they don't get any more time unless the landlord wants to give them more time. Also, the third notice is the notice to the San Diego Housing Commission. Now, the Housing Commission is in the process of creating a portal for submission of notices. So this part, notice to commission, is not effective until after the commission creates the portal. And as of today, there's a new website. I have the link here in the slides. The San Diego Housing Commission has a new page on their website that provides an explanation of why the portal is not ready yet. They're working on an MOU with the city. Anyway, so once the portal is ready, it's 3 notices to cure. As of today, it's 2 notices to cure. And we're just ignoring that notice to the commission until we receive notice that the portal is ready. The at-fault just causes listed in the San Diego law include default in payment of rent, or a breach of a material term of the lease as described in our Code of Civil Procedure 1161-3. And then maintaining a nuisance, committing waste, those are our 1161-4 notices to ways of terminating the tenancy. Refusing to renew a lease. Oh, do we also have subleasing? I don't want to skip over it, but subleasing is another at-fault just cause if the tenant's lease does not allow them to sublease, and that's also one of our 1161 for termination of tenancy reasons. Then we have if the tenant refuses to renew the lease. So this is when the prior lease term has expired. The landlord offers the tenant a new lease. Then the new proposed lease has to be substantially similar in duration and with substantially similar provisions in order to trigger the right to evict the tenant for offering the lease and then the tenant's refusal to sign the lease. There is an interesting provision written into this law that we'll cover later where something will need to be added to your lease to reserve the right for the landlord to move into the property and to use that as a no-fault just cause. And that is specifically deemed to be a similar provision. So if you're just amending your lease to add that provision, that will be deemed substantially similar. Okay, another at-fault just cause is criminal activity or criminal threats. I mentioned subleasing and assigning in violation of the lease. If the tenant refuses to allow the landlord to enter the premises, then the tenant may be evicted for that reason. If the tenant is using the property for an unlawful purpose. And then we have if the tenant is occupying the property because they are an employee or an agent or a licensee of the landlord, and then that employment or the agency or the license is terminated, that can be the basis for an eviction. But when I've dealt with these situations, what must be documented is that in the lease, the tenant's right to occupy because of the employment or because of the agency, that needs to be tied in because you often have an employment contract and a lease as separate documents, and they need to be connected. And then you have situations where the tenant gives notice that they want to move out of the premises, and they give the landlord a written something, an email, a text message, or something stating that they intend to move out on, July 1st. If the tenant then fails to move out, that may be used as a reason to terminate the tenancy. All right, so those are all of our at-fault just causes. Only some of them are curable. Only some of them allow for the extra notices of the right to cure and then termination. The ones that are non-curable, you can just do the notice of termination of tenancy, and then eventually we'll have to do the notice to the commission when that portal becomes active. The no-fault just cause portion of this new ordinance is very different. First, it starts off explicitly stating that the no-fault just cause is any of these things taken by the landlord, but the landlord must act in good faith. And they define that good faith means the landlord acts without ulterior motives and with honest intent. I like this language. It actually clears up something further down in the statute, but it is very unique. And it points us toward the potential that tenants may find reason to sue. There are some remedies in the statute that give the tenant an incentive to sue the landlord, such as, in the statute, any violation may allow the tenant to recover attorney's fees and punitive damages, 3 times actual damages, 3 times the relocation assistance. So you want to watch out and make sure that if you do have to go to court, you can prove that you're acting in good faith and you don't have an ulterior motive to, terminate the tenancy. This is particularly for those no-fault reasons. So no-fault reason number 1, the landlord seeks to recover possession to occupy the property for the landlord's use or their spouse, domestic partner, child by blood or adoption, grandchild by blood or adoption, parent or grandparent. Interestingly, they have removed siblings. Under the California law, siblings are included. under the rent cap just cause. Under San Diego, siblings are not included. And in order to preserve your right, to reserve the right to use this as a no-fault just cause, the new law requires that your lease states or the tenant agrees that you can terminate the tenancy if the landlord unilaterally decides to occupy the property. So for leases that are entered into after the effective date of this law, so after June 24th, which already passed, the new leases must include this as a provision of your lease, that the landlord reserves the right to terminate the tenancy based on the landlord's intent to occupy the property. For tenancies that were in effect prior to the effective date of the law, existing leases seem to be grandfathered in. They don't give you the right to issue a notice to your tenant to claim this change. But if you renew the lease, or you have a new fixed term lease or a new lease of any kind, this change is considered substantially similar. So you want to include this in any new lease, and it is substantially similar. Whether you want to offer your tenant a new addendum to their existing lease and add this clause, that is up to you. It is going into my new San Diego addendum that I have been working on and have tried to incorporate all of this stuff into. Okay, so then we have the no fault just cause that the landlord seeks to withdraw the property from the residential rental market. This vague reason is included in the California rent cap just cause law as well, and I've struggled with it, but the addition of this good faith language in this law really clarifies it. So so this is a reason we often use when someone wants to sell the property and they don't want to sell it with the tenant in place because for one reason or another, the tenant is a problem, or it's a, they think maybe they can sell the property for more by removing the tenant. So, we get called upon to try to get the tenant out so that they can list and sell the property. That qualifies as withdrawing the property from the residential rental market. The gray area is, well, what if you sell it to an investor who then immediately re-rents the property to a tenant? I believe that the seller, the person who's trying to get this tenant out prior to selling, is acting in good faith as long as their complete intention is to sell the property. They're just removing the property from the rental market as far as they're concerned. And this provision also supports California's law, which is that California supports the landlord's right to go out of business. So those two things together, the good faith act that they are definitely selling the property and the landlord's right to go out of business, mean that you can withdraw the property from the rental market if your intention is to sell it. There are other reasons why people withdraw the property from the rental market. But I would not use this as a workaround to avoid reserving the right to move into the property. Since that's specifically set forth in the statute, you need to think of these as two separate things. Withdrawing from the rental market does not include the landlord's intention to move into the property. What's nice is they don't say here that you have to withdraw every unit on the parcel. The California law includes that you have to withdraw all the units from the parcel. Or maybe that's changed actually. I'll have to look back at that because I was just looking at it and it actually doesn't say that anymore. Okay, so another good no fault reason is the landlord seeks to recover possession to comply with a government order. It could be an order issued by any government agency ordering that the property be vacated, or an order issued by the government agency or a court relating to habitability that requires vacating the property for at least 30 days. It could also be a local ordinance that requires vacating the property. If the tenant is causing the problem, that requires that, the government has now issued a notice of enforcement, a civil penalty notice and order, some kind of code enforcement issue. If it's caused by the tenant, you do not have to pay the tenant relocation assistance. Now, let's talk about the reason that, the landlord is going to do a substantial remodel of the property. This is an interesting and very different provision in the San Diego ordinance from anything that I've seen before. In this case, if the landlord wants to do a substantial remodel, they must go through 3 steps. Step number 1, a copy of the permit application needs to be given to the tenant, notifying them that the landlord has applied for permits. Step number 2, the landlord secures the permits necessary for the demolition and substantial remodel. And step number 3, the landlord serves a copy of the necessary permits with a written notice of termination of tenancy, and it must be certified under penalty of perjury, stating the reason for termination, the type and scope of the work to be performed, why the work can't be reasonably accomplished in a safe manner with the tenant in place, and why the work requires the tenant to vacate the property for at least 30 days. So the 30-day provision is a big one. So the remodel must take at least 30 days, and you have to give them all of these notices, all of this notice. The statute defines substantial remodel. It's very, very similar to what the California statute says, which is that it can't be, basically it can't be cosmetic. It has to be structural, it has to require permits, all of that good stuff. Other details for no fault just cause. We talked about the good faith requirement and the different descriptions of the just causes that may be used. The notice to the tenant also has to include 2, or depending on the type of tenant, 2 or 3 months of relocation assistance, and notify the tenant of their right to an offer to renew the tenancy. And then we also have to give notice to the commission once the commission's portal is up and running. We'll talk about the relocation and the right to renew in a minute. All right, so another new thing in this new law is the new tenant protection guide and notice to the tenant of the tenant protections. So these items must be provided to tenants in properties that are not exempt from this law. For existing leases, it must be provided within 90 days of the effective date of the law. So that would be on or before September 22nd, 2023. And then for new leases that are entered into after June 24th, meaning June 25th, which was last Saturday, and moving forward, it has to be required with the new lease. These items are currently available. The San Diego Housing Commission has provided the tenant protection guide. You can get it from their website. Here is the link on this slide. I will also send it as the free resource when we send that out with this seminar. And let's see, the portal will be effective. This submission of notices through the portal will be effective 30 days after the portal is created. And based on the explanation on the San Diego Housing Commission website, that portal is not being created until a memorandum of understanding has been entered into in the city, and then they're going to do a request for submission for contractors who are going to create and run the portal. And so there's a whole bunch of stuff that needs to take place before we have to submit things to the commission. But you do have to attach the tenant protection guide to your new leases, and you must provide a copy of it to your existing tenants prior to September 22nd, as well as the notice of tenant protection. So the new notice of tenant protection states, as set forth on this slide down at the bottom, California law limits the amount your rent can be increased. See California Civil Code section 1947.12 for more information. Local law also provides that a landlord shall provide a statement of cause in any notice to terminate a tenancy. In some circumstances, tenants who are seniors, 62 years or older, or disabled may be entitled to additional tenant protections. And then it cites the municipal code. All right. So then for non-exempt properties, When the landlord is using a no fault just cause to terminate the tenancy, so no fault just cause, that's that series where the tenant has not caused their own eviction, the landlord must provide 2 months of relocation assistance for most tenants. If the tenant is elderly, over the age of 62, or disabled, they have to provide 3 months of relocation assistance. And by the way, that second bullet point cut off everything after and. The and was moved down below, sorry. And in all cases, the landlord has to provide notice of the tenant's right to receive an offer to renew the tenancy. With regard to the relocation assistance, this is a sticky issue. How do you know a tenant's age or whether they have a disability? Well, of course, if the tenant offers that information to the landlord, great, now the landlord is on notice. I don't recommend that all landlords now go and ask their tenants their age or their disability, because that can get you into some trouble. People start to think that maybe they're being discriminated against. Rather, I think that in an application at the beginning of the tenancy, before the tenant has been offered a lease, the application could provide some optional questions about age and disability, and the landlord doesn't necessarily need to, the tenant doesn't necessarily need to answer them. Most tenant applications do ask for date of birth, or you get a copy of the tenant's driver's license. And so there are other resources that you may have on hand to know the tenant's age and whether they have a disability. So I would also make sure to look at those resources before you issue any notices, so that you know how much relocation assistance is required. If the tenant owes past due rent, you may credit the relocation assistance to the past due rent. You can, instead of paying cash to the tenant, you can waive rent. If you're using a 60-day notice and you only owe 2 months of relocation assistance, you could waive the remainder of the rent. If it's a 30-day notice, you could waive the 30 days of rent. And then if they've missed a month of rent, maybe you could credit it back to that. I don't know. There are different ways that this could be resolved. I know landlords prefer to waive the rent, but in this case, that may not always be possible, since we have to do 2 months or 3 months. Okay, the notice of right to receive an offer to renew the tenancy it lasts for 5 years after the tenant has vacated the property. The landlord has to give, within the notice to terminate the tenancy, the landlord has to tell the tenant that they have 30 days to notify the landlord of their desire to have the right to renew the tenancy. The tenant has to provide their mailing address or email address, and the tenant has to update that information throughout the duration of the following 5 years. And then if the property comes back on the market for rental, the landlord has to contact them and offer it to them first. Now, the landlord is allowed to review the tenant again financially, take a new application, check their background, and qualify them for the tenancy as though they were a new tenant. And the landlord can increase the rent to fair market value. So that is that. So this is a list of 5 of the 6 major changes in the law. The last one we're going to talk about next. So we have the new tenant protection guide and the additional notice that has to be provided to the tenants within 90 days for existing leases, or for all new leases in non-exempt properties. We have, for exempt properties, the landlord has to claim the exemption, similar to with the California rent cap just cause claim of exemption. And it doesn't have to be a part of your lease until January 1st, 2024. But for new leases, it's recommended that you may have it in there, and you should give the tenant the claim of exemption as soon as possible as a separate notice. So if the landlord wants to reserve the right to use the landlord's intention to move into the property as a reason to terminate the tenancy, that has to be incorporated into the lease. And then for at fault and no fault just causes, notices have to be submitted to the San Diego Housing Commission when the tenancy is being terminated. And again, that doesn't go into effect until 30 days after the Housing Commission creates the portal, and there is no portal yet. And then for no fault just cause, the relocation assistance is required either 2 times or 3 times the monthly rent, and notice of the tenant's right to renew the tenancy, and notice to the San Diego Housing Commission. All right. So then the last big change here, well, we'll talk about the last 3 big changes, but the major thing is for buyout agreements. A buyout agreement is also called a move-out agreement, a cash for keys agreement. And with these, the city of San Diego requires that the landlord first provide a written disclosure to the tenant prior to making any offer of cash for keys, or prior to making any offer of a buyout agreement. That disclosure, I haven't been turning my pages here. That disclosure must state that the tenant has the right not to enter into a buyout agreement. A statement that the tenant may choose to consult with an attorney prior to entering into the buyout agreement. A statement that the landlord may not retaliate against the tenant who doesn't want to enter into a buyout agreement. A statement that all tenants of a residential property may refuse to receive a buyout offer by giving the landlord a written notice of their refusal. And that written notice is effective for 6 months. The tenants may also rescind the refusal to receive the buyout offer in writing. And then the statement must also include that the tenant is eligible for relocation assistance in the amount that the relocation assistance would be if the tenancy were being terminated. It must include the names of all of the people that are authorized to discuss a buyout offer with the tenant on the landlord's behalf. So if the landlord has a property manager or a power of attorney, somebody who is acting as their agent, it has to let the tenant know that that's all the names of the people that they can talk to about it. And then it has to have a space for the tenant to sign and date, and a space for the landlord to sign and date. The landlord must provide a copy of this full disclosure and then maintain a copy of the disclosure for themselves for 5 years. The copy of the disclosure fully executed must be provided to the tenant within 3 days of its complete execution. And that's all. I mean, you know, simple as that, right? Then, after all this disclosure stuff has been done, in order for the landlord to provide the buyout agreement, the landlord has to comply with the following. The buyout agreement has to be in writing. That part's easy. A copy of the buyout agreement has to be given to each tenant at the time that the tenant signs the buyout agreement. The buyout agreement must include the following statements in bold letters in 14-point font in close proximity to the space of the signature. Here's what it has to say. You, the tenant, have the right not to enter into this buyout agreement. If you, the tenant, are entitled to relocation assistance under federal, state, or local law, a buyout agreement for less than the amount of the relocation assistance to which you are entitled violates Chapter 9, Article 8, Division 7 of the San Diego Municipal Code and is void. You, the tenant, may choose to consult with an attorney before signing this agreement. So that needs to be in bold 14-point font in the buyout agreement. If the tenant primarily talks to the landlord in a language other than English, then all of this stuff has to be provided in the language that they primarily use. And then if the buyout agreement does not strictly comply with this, the buyout agreement may be considered void. Also, the amount of the buyout, the amount of the buyout, the cash for the keys, has to be more than what the tenant is entitled to as relocation assistance. So if they're entitled to 2 months relocation assistance, then the buyout agreement has to be $1 more than that amount. Or if they're entitled to 3 months, it has to be more than that. All right. And these provisions cannot be waived in your lease. It says no waiver. So you can't just put it in your lease that the tenant waives this. There's a strict retaliation prohibition in the law, so you can't retaliate against the tenant. No surprises there. And then the remedies included in the law are quite unique. Harken back to the County of San Diego when they told us that we couldn't evict anyone except for, public nuisance. These are similar, that the remedies, the tenant claiming a violation of this division may sue the landlord. The tenant may seek injunctive relief, meaning stopping any eviction, equitable relief and money damages, including punitive damages in a civil action against the landlord. The tenant may raise a violation of this as a defense to an eviction or any other kind of action by the landlord against them. Any attempt by the landlord to recover possession of the property or any actual recovery of the possession of the property in violation of this division causes the landlord to be liable for wrongful eviction. Any landlord who fails to provide relocation assistance as required shall be liable to the tenant in a civil action for not less than 3 times the required relocation assistance plus actual economic damages. So 3 times the relocation assistance would be 6, if it's, 2, if they owe 2 months of rent, it's 6 times the monthly rent plus actual damages. The prevailing party in such an action shall recover costs and reasonable attorney's fees, and these remedies can be added on to any other remedies allowed by law. Also, the city may enforce this provision. So if the city sees some violations, they can take it upon themselves. The city attorney's office can enforce them. All right, and so all of these laws are effective as of last Friday, or last Saturday, technically. All right. I wanted to just mention we've got a bunch of other new laws. Short-term residential occupancy licenses required in the city of San Diego as of May 1st. County of Los Angeles has some new tenant protection laws. Chula Vista has its new tenant protection law, which is complicated. The new rent cap has been calculated and remains at 10% for the next year for leases that take effect after August 1st of the year. Your properties that are not exempt from the rent cap just cause law in California, you can stay at 10%. It has not gone down. It's capped at 10%. And then just an update on unlawful detainer litigation. So when we file evictions, if the tenant does not move out during the eviction, then we have to get a judgment. And then that judgment goes to the sheriff, and the sheriff may perform the lockout. The timing for getting the paperwork that goes to the sheriff is taking a long time. So, the courts are proceeding pretty well at getting cases to trial or at defaulting people and getting that paperwork through. But once we submit the judgment paperwork and the writ of execution for the writ of possession, if we're doing possession only and it's a default judgment, as of today, the clerk is working on things that were submitted on May 5th. So they are about just under 2 months behind. For a court judgment, meaning that if it's a default judgment that has to go to the court, that means that it is for possession and money, or possession and something else that the court needs to look at. Those, as of today, are working on things submitted March 21st. So those are about 3 months behind. And then post-trial judgments, cases that go to trial, the court enters judgment in the courtroom, but then we still have to submit the paperwork. Those, they say, are being processed as of February 6th. But we just received 2 this month I'm sorry, we just received 2 of them this week that were entered at trial in early May. So I don't know why they're giving us this February date, but it looks like they're working on May. All right, and then this QR code, which you may have seen on some of the other slides, takes you to our free resources, not our free resources, our resource page. So if you want to be on our list, if you did not get the invitation for this webinar, but somebody else gave it to you, you can sign up for our resource list using this QR code, and then you'll be in our system and you'll get our newsletter and other stuff as well. We're also on LinkedIn, Instagram, Facebook, and YouTube. Feel free to find us on there, like us, and follow us. And then if you do have specific questions relating to a case or you want to refer somebody over, phone number is here, the email address is here, and reach us any way that you can.